right now on the Daily Debrief.
Bang, 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 bang.
Opening statements in a Tennessee murder trial where the defendant blames the victim.
Molestation, manipulation, and mischaracterization. That's what this case is.
Is the shooting excusable?
He attacked my client because my client recorded him confessing something that put him in jail for a very long time.
And the subject of the podcast Serial wants the Supreme Court to take his case. Also, new accusations against the estate of a millionaire pedophile as his will turns up in the Virgin Islands. Plus, murder or self-defense. Jury selection in a Florida shooting caught on video. The Daily Debrief recaps the day in court. It's Tuesday, August 20th.
Welcome to the Debrief, everybody. Aaron Keller, along with Catherine and Mike. Our other guests will be with us in just a moment. Opening statements in the case of a Tennessee man accused of killing another man who he thought, that is, the defendant thought, had molested his girlfriend. 25-year-old Sean Foley is accused of gunning down 44-year-old Jimmy Shelton. The defense claims that when Foley confronted the victim attacked him, and so he used deadly force in self-defense. Prosecutors disagree and charge Foley with one count of first-degree murder. He faces up to life in prison if he's convicted. Let's begin tonight with how the prosecutor described the actual shooting.
He waits until Jimmy and Miranda start to make good on their deal. And that's when he acts. He goes to his backpack. He opens his backpack. He procures his weapon. He removes his Springfield subcompact .40. He goes through the house and walks to the door to the back porch. And that's when he confronts them. On the porch, on Jimmy Shelton's own porch, he raises his gun and he points it at Jimmy Shelton. And that's when he threatens him. He threatens him and says, "If you touch her again, I'm going to drop you." Now, I don't know whether it's courage or foolishness or just intoxication, but Jimmy Shelton doesn't cower to this man pointing a gun in his face, Sean Foley. Miranda walks up. What does she say? "Sean, stop. Sean, stop." Sean ain't having it. And when Jimmy doesn't cower, when Jimmy doesn't back down, Sean Foley unloads on him. Bang, 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 bang. 8 shots. 8 shots on the back porch of this home with multiple completely innocent people and children inside. 8 shots. His girlfriend just a couple feet away. Sean unloads 8 times. 4 of these shots strike Jimmy. 2 in the chest, 1 in the neck, 1 in the side.
The prosecution said the woman behind this whole scenario was 25-year-old Miranda Goddard. She had been locked up in jail for a couple of weeks prior to the shooting. The victim provided the cash to bond Miranda out of jail.
There's not really any other way to say this, but she has a bit of a different lifestyle. She has a history of using her body to help financially support herself. She engages in modeling, often very scantily clad. She has previously worked as an exotic dancer. She had and does sell erotic photos and videos of herself to private parties for a profit. That's what she does to help financially support herself. Sean Foley knew this on the night of the shooting. He knew what Miranda Goddard did. He recorded the conversation between the two of them. The state submits that the proof will show that on August 28th, that is exactly what was happening. Miranda Goddard was using her body to try to negotiate a deal with Jimmy Shelton. And Sean Foley wasn't going to have any of it. How long did they talk about this deal? She was going to use her body to get a vehicle, a car, from Jimmy Shelton for her and Sean to use.
Let's check in with the panel very quickly on the state's opening statements. We have 4 attorneys with us here on the Debrief: Eklund Mercy, Catherine Smith, Mike Korobanix, Linda Kenny-Bodden. Let's begin in studio. So, Catherine, how do you think the state did overall setting up this scenario, which the state says was premeditation?
I think they did a really good job of it, though I don't like how they tried to sully the reputation of the victim, of Miranda, in fact. I think the bottom line is this: whether there was molestation or not, this sounds to me like a jealous rage.
Exactly. Okay, Mike Korobanics, I was thinking the same thing that Catherine was, listening to them, in your words, Catherine, sully the reputation of this other person who was present, who could potentially be described as a victim depending on how states view victims. In some states, it'd be very clear that she would also be a victim too.
I think it's a very dangerous road they're traveling, and unless they're somehow going to tie that together as if this was all an entrapment for this to occur.
Linda Kenny Bodden, let me jump in with you. You're out in the newsroom right now for us here at Law and Crime. So we have 8 shots here. That's a lot of shots. Is that premeditation in your book? Is it something else?
I find him guilty right now. If I'm the jury, I think it's premeditation. He taped it for 22 minutes. He was in a jealous rage. There's simply no reason for shooting Jimmy Shelton, in my opinion.
Eklund Mercy, you're in Atlanta, Georgia. Okay, how do you take this? Is this premeditation, or is this someone who's defending himself from an attack by the victim, which is what the defense says?
I'm thinking there was adequate provocation. I would look at it more as a manslaughter because there's a whole bunch of witnesses. They were on the porch drinking on a summer day. So I don't see it as premeditated. I don't see him as lying in wait. He was recording everything. So I don't see it as premeditation. I see it as adequate provocation.
Eklund Mercy going for the lesser charge there. Appreciate the perspective there, certainly from the panel. Let's move along now to what the defense said. And the defense claims this entire thing escalated. They blamed the victim for allegedly molesting the defendant's girlfriend.
Manipulation and mischaracterization. That's what this case is. Jimmy Shelton molested Miranda from the time she was 12 years old. And it continued. The state's correct. She's 25 now. That damage that was caused all the way until she was 25 remains. He pulls her down onto his lap, puts his hand down her pants, hand up her shirt. Sean, for 22 minutes and 47 seconds, stood inside of a window, recording him, confessing to molesting her throughout her entire childhood. When he ran his hand down her pants, and his other hand up her shirt, Sean saw something that he'd seen before. Saw her go to a place and lock up. He went out there to stop that rape. He didn't shoot him through the window while he was sitting there watching. That's how you premeditated and kill somebody. When he gets out on the porch, he says, "If you ever touch her again, I'll drop you." That's a threat. You're not going out there to kill him.
Okay, the defense said everything got way worse when the victim attacked the defendant. Listen to this description.
Something else happens, and you're going to hear it on the audio recording. It's easy. Jimmy Shelton, the man that he is, 220 pounds, 6'3", crosses that porch. It's stretched. And you're going to hear how far it is, exactly, in a quick fashion. And he's shot 4 times because he attacked Sean. This evidence is going to show today that he attacked my client because my client recorded him confessing to molesting Miranda Goddard, something that put him in jail for a very long time. The client thought he was going to kill her. You're going to see those gunshot wounds. Okay? One that went into the neck right here. Okay? It's at a downward angle. We'll hear about that. Okay? Jimmy is much taller than Sean. Sean didn't jump up and shoot down or anything crazy. You get that downward angle one way, like this. Like a linebacker. Attacking him. He wasn't coming to give him a hug. He's coming to kill him. Keep all that evidence a secret. Store that recording. That's what the evidence is going to show today. The client acted in self-defense and with necessity.
Wow, there really are 2 sides to this story. The first witness called to the stand played the defendant's own 911 call to report that he had shot the victim.
911, I'm in LA, Beaver right now. guy, fucking shots fired. My girlfriend's being molested by her stepdad. I need police here now. Shots fired, shots fired. Your hands were down. I need police here now. I have my weapon drawn, sir. My name is Sean Foley. Yes, sir. Miranda, come here now. Please come here. I was recording. He was trying to rape you for a car. Yes, sir. Yes, sir.
All right, listen.
Yes, sir. They said he's not breathing.
Who's not breathing?
Yes, sir. The guy that I fired on, he was trying to rape my girlfriend. Please, they're all on the phone right now. I need officers here now, sir. My name is Sean Foley. I'm an Army veteran, sir. Honorable discharge. I have my carry permit. I have it on recording. He was trying to rape my girlfriend. Car. I came outside and told him to stop. She pulled her pants up. He rushed me. I opened fire, sir. I need officers here now.
Okay, sir, listen to me. Calm down just a minute.
Yes, sir.
We're getting them on the way.
Next, one of the first responding officers testified about finding the victim on the back deck of the home where he was called.
When we come around the corner of the house, we've seen a female right there was attempting to do CPR. Made contact, asked him to step away. I checked for a pulse. There was no pulse. There was a white male. He was wearing red shorts. You could see blood that was coming to I believe it was a white T-shirt. He had wounds to the chest and one to the neck, and he was blue. And there was spent shell casings.
You say you secured the scene. What do you do when you secure the scene?
We preserve the evidence. We get everybody that's there off, pretty much away from the.
Let's go back to the panel on this side of the case, this part of the case. Eklund Mercy and Linda Kenny Bodden to start now. Let's start with you, Eklund, here. Evidence of a crime, attack, self-defense. What do you think here? Do you think that this particular victim was killed because he attacked the defendant, because the defendant had evidence that the victim was committing the crime? It sounds at least a little bit plausible to me, but I need a lot more testimony to make my mind up.
Yeah, but the defense actually put their theme down, in which Linda has stated repeatedly: molestation, manipulation, and mischaracterization. He has a theme, and the theme has been consistent with their story. As long as they make it so that their theme is consistent with the story that they're trying to tell the jury, I believe that it can be successful. Even in his opening, when he talked about the trajectory of the bullet going downward and how it would have to be because he was being rushed, that's plausible to a jury.
I was wondering about that as well. So, Linda, I'll throw that question your way. Okay, is the downward trajectory a sign, as the defense says, that this crime was, or this shooting, I should say, happened because the defendant was being rushed like a linebacker would rush him? Or is it a sign that this is way more nefarious, that the defendant was shooting the victim when the victim was already down?
It could be either, Aaron. It depends on where the defendant is and what the victim is. For instance, if the victim has been shot, if Sheldon was shot in his chest and he starts falling downwards, he could get shot in that angle on the neck and an upward trajectory. So it's the relationship between the two, not just the angle of the shot.
Okay, Mike Korobanix, I'm going to jump in with you here in studio in New York. So who has to take the stand here? Does the defendant have to take the stand here? Does the girlfriend have to take the stand here?
I think you want the girlfriend to take the stand so the defendant doesn't have to, but I think that opening was great, and I thought it was very concise, like I'm going to try to be, and it got to where they need to be.
Oh, look, I think we all agree here that whether we agree with the defense theme or not, the defense had a theme here, and oftentimes the defense doesn't have a theme. So, Catherine, one thing I'm noticing is not only was the defense succinct with a theme, but the defendant started the theme with the 911 call, and it's carrying all the way through the case.
He sure did, but you know what he did not say in that 911 call right away? He didn't say, "Help, I've just been attacked." He said that my girlfriend's pants were down. To me, that shows that he was more jealous and angry, less than defending himself.
So you're speaking like a prosecutor now. You thinking about switching into the prosecutor chair?
I am not. I cringed when I sound that.
And Mike is sitting here saying, "Hire me, I'll defend you." Wow.
I'm getting ready to move.
All right, straight ahead here on the debrief. The estate of the millionaire pedophile who killed himself in jail is facing some new legal liability. Plus, jury selection in a Florida case of manslaughter or self-defense. Watch the video and decide for yourself. Welcome back, everybody. 3 new lawsuits tonight against the estate of millionaire pedophile Jeffrey Epstein. The cases say Epstein took one accuser's passport so that she could not leave his island, and they say he forced a sex toy on another accuser. The cases even say Epstein used his work release privileges to perpetrate more sexual abuse. Epstein's will turned up in the Virgin Islands yesterday. He signed it 2 days before officials say he committed suicide. He left his $578 million estate to a trust. From there, it's difficult to track where he wanted to put the money. The case of the defendant who became the subject of the podcast Serial may be headed to the Supreme Court. Adnan Syed was convicted of killing a female classmate, but his appeals attorneys say his trial attorney was deficient. The legal issue for the Supreme Court is whether the state appeals court made a mistake by hypothesizing that a jury would probably not have believed a so-called alibi witness, even if the witness was called. The original trial attorney never called the alibi witness, and the lower courts reasoned that it didn't matter because the witness contradicted the defendant's own statements and would rather have made him look like a liar. The Supreme Court rarely accepts appeals such as this one. Now to other trials we are following this week here on Law and Crime. The so-called sanity phase of the case of the California Ripper began today. A jury convicted Michael Gargiulo of killing 2 women and trying to kill 1 more. The question now is whether Gargiulo was legally insane when he committed those crimes. A jury has been seated in the case of a Florida man shot and killed after a fight over a handicapped parking space. Michael Drake is accused of manslaughter with a firearm after he gunned down Marquis McLaughlin. Prosecutors say Drake confronted the victim's girlfriend for parking in the handicapped space without a permit. The victim pushed Drake, so Drake pulled out his gun. Drake had a concealed carry permit, and from there, Drake says the victim made a twitch, so he fired and claimed self-defense. At first, the police agreed with the defendant that this was not a case of, or it was rather a case of self-defense, not a crime, but authorities later changed their minds. At the center of this case is the surveillance footage of the shooting.
The video recorded in the parking lot where the shooting occurred shows the defendant, Michael Drake, presumably pointing out the handicapped parking spot where victim Marquise McLaughlin's girlfriend had parked. Then the victim emerges from the store, hurries to the defendant, and shoves him. The defendant, from the ground, pulls his weapon and fires. McLaughlin, injured, runs back into the store. Was it self-defense or a criminal act? New York Law School professor and former NYPD detective Kirk Burkhalter analyzed the recording for Law and Crime.
Now, a key point here is that once the defendant drew his weapon, the victim took 1 step back. So if you freeze that moment in time, the threat was over. Theoretically.
Burkhalter notes that in some states, the shooter would clearly be criminally liable, but in Florida, the law is different.
In New York, for instance, I would think that the law enforcement would view the victim as retreating. However, in Florida, there's a couple of things. There's the stand your ground law, and also the use of force doesn't necessarily have to be proportional to the perceived threat.
The legal question is whether the use of a gun is reasonable. It's a legal term often used, but hard for many juries to apply.
Law enforcement will first look at the reasonableness of the perception of the threat, the proportionality of the use of force, and finally, the totality of the defendant's actions. Was the defendant the initial aggressor? So, for instance, in this case, while the defendant started this entire situation by approaching the vehicle, the defendant was not the initial aggressor with the victim. Arguably, the victim was the initial aggressor because he pushed the defendant to the ground.
Then, Burkhalter says, comes the question about the defendant's state of mind. Understanding what he was thinking and what is seen in the video will give the jury much to consider.
The video, at the end of the day, is somewhat damning.
Attorney Michelle Rayner Goolsby is representing the victim's parents in Florida. She appeared on the Law and Crime Network earlier to discuss jury selection from the perspective of the family.
This is the most pivotal time for any trial because you have to get 6 individuals that can lay aside their biases, lay aside their opinions, lay aside all of those things and make a decision based on the facts and the law. The maximum that he could get under Florida statute is 30 years. So the family has been very adamant that they want him to be convicted or, he's going to have to plead to 30 years, right? Part of their journey. It is one of the hardest parts of their journey. And I think that right now they're very focused on this trial, very focused on getting a conviction. It is hard because, as I don't know if you're aware, the defense has really used the opportunity for pretrial hearings to really try to paint Marquise as someone that he was not. So, to be able to have to sit through that and then have your hope for justice in the hands of 6 other people, that's a lot, and it is nerve-wracking. And so, they're doing as well as can be expected.
Back to our panel for some analysis on this case. Let's start with Linda Kenny-Bodden and Eklund Mercy joining us from outside the studio. So, Eklund, we've got 6 people on juries in Florida, such as this one. They narrowed it down from 42 people today to the final 6. There aren't any African Americans represented. We have an African American victim here. Does that play a serious issue as this case is going to move forward?
Absolutely, it does. We've had the same issue with the Trayvon Martin case. We've had the same issues with cases dealing with racial discrimination, and it does play a part in this case. You're going to have Mr. McLaughlin is trying to defend his girlfriend in the car, and you have this in his perspective. You have this angry white man who doesn't work there, who isn't disabled, yelling at your girlfriend about this disabled parking lot. And if you're not a cross section of that community, if you don't understand where Mr. McLaughlin was coming from, it's going to be hard as a juror to believe the prosecution. It's going to be difficult.
I agree with that as well. Linda Kenny-Bodden, your thoughts?
I think that the film is so clear. I was just paralyzed with fear myself when I saw the gun come out and the shooting. I think this is a guilty without a doubt. I don't know. I seem to be on the other side of everybody today, Aaron, with a guilty verdict, and I'm a defense attorney.
Yeah, that surprises me. I don't know if I'm talking to the real Linda here. Let me bring it in studio here. So, Catherine Smith, I think the video says a lot about this. Let's talk a little bit more about the jury. They were asked a lot of questions. What do you think of self-defense? What do you think of handicap parking permits? That's what they were drilling at when they seated this jury.
Yeah, it's bizarre. You really want to get, though, to the very end of whether there are any biases that the jurors have that would have them immediately predisposed to not listening to the facts and to feeling some sort of sympathy for either the victim or the defendant. And hopefully they weeded them all out.
Mike Korobanix, a couple of seconds left here. If I'm the prosecutor on opening statements tomorrow, I am playing the video multiple times. What do you think?
I don't know. I think that video, when it gets some context, is going to be a problem on both sides, because there's one part of that video where after he pushes him, he goes to his back and then he steps back. But the other problem is that his hands are there when he's shot.
Yeah, exactly. We're out of time here on The Debrief. Thanks to the panel. We'll see you tomorrow.